To make this panel's discussion less abstract and to relate it directly to the issue at hand, I'm going to give you some examples of situations that have arisen in which the holder of a perpetual conservation easement agreed to substantially modify or terminate the easement, and the response of state attorneys general, concerned citizens, and the courts. It's useful to note at this point that the extent to which conservation easements are being properly or improperly modified or terminated is unknown, because there's no ready data on the issue. And going back to the elephant in the room, there really isn't any agreement regarding what constitutes proper or improper modification and termination. As for data gathering, since 2006, the IRS has required nonprofits to report on their conservation easement modification and termination activities as part of their annual Form 990 filings. While this is a start, a glance at the Form 990s shows that the self-reporting is a bit spotty. Land trusts that hold conservation easements but file Form 990 EZs because they don't have substantial financial assets, even though they do hold easements, are not required to report on their modification and termination activities. And government entities, which, as we saw, hold conservation easements encumbering millions of acres, are not required to file Form 990s. Moreover, it's not clear what the IRS intends to do with all this data or the extent to which state regulators are even aware of the data. So now, turning to the cases and controversies. First, we have the Myrtle Grove controversy out of Maryland. In 1975, Margaret Donahoe donated a perpetual easement encumbering this 160-acre historic tobacco plantation located on Maryland's eastern shore to the National Trust for Historic Preservation. This property is known as Myrtle Grove, and as you can see, it sits on a peninsula extending into a tributary of the Chesapeake Bay. This property had been in Donahoe's family for 8 generations. She and her brother had each inherited a portion at the death of their father, and the brother later sold his share for development into 5-acre residential lots. Donahoe deeply resented what her brother had done, and in 1975 she donated a perpetual conservation easement to the National Trust after being informed by the trust that the easement would permanently protect her share of the property from similar development. After Donahoe's death, her descendants, who were apparently unable to pay the estate tax on the property, sold the land subject to the perpetual conservation easement to a prominent Washington, D.C. developer. The developer spent considerable time and money renovating the manor house and the other structures on the property. After the renovations, the developer tried to sell the property as an estate, but he was unable to do so because the market for large estates had gone south during the renovation process. So, after consulting with his real estate agent, who told him that the property would be much easier to sell if it could be developed into multiple high-end residential lots, the developer went to the National Trust and asked the National Trust to amend the easement to narrow its application to a 47-acre historic core surrounding the manor house and permit a 6-lot subdivision on the remaining property, complete with a single-family residence, ancillary structures, pool house, tennis courts, gazebos, etc. on each of the lots. In other words, the developer wanted to create a 7-lot upscale subdivision on this property. Despite its earlier representations to Donahoe and her heirs and the express terms of the easement deed, the National Trust agreed with the developer to amend the easement as requested. Unsurprisingly, this decision touched off a storm of protest from conservation groups, local and national media, and Donahoe's daughters. The National Trust eventually acknowledged that it had made a mistake and it withdrew its agreement to amend the easement, at which point the developer sued the National Trust for breach of contract, asking for specific performance of the agreement to amend or $250,000 of contract damages. The Maryland Attorney General then got involved and filed a separate suit asserting that the donation of the easement had created a charitable trust and the easement could not be amended as proposed without court approval in a cypre proceeding where it would have to be shown that the purpose of the easement had become impossible or impracticable, which clearly was not the case. This easement was donated before Section 170H was enacted, and it did not contain the standard judicial proceeding extinguishment language that you tend to see now in tax-deductible easements. This easement was actually silent on the issue of termination. The Nature Conservancy, the Land Trust Alliance, and certain other conservation and historic preservation groups filed an amicus brief in support of the AG's position in this case, and this case eventually settled with the National Trust agreeing to pay the developer $225,000 and the parties agreeing that to the extent that the National Trust is granted discretion in the easement deed, no action can be taken to amend, release, or extinguish this easement without the express written consent of the Maryland Attorney General. This property is still protected by the easement, and the last time I checked, the same developer still owned the land. Next, we have the Walmart controversy out of Tennessee, in which the city of Chattanooga, which held a perpetual conservation easement encumbering an 8-acre parcel along this creek, permitted the development corporation that owned the parcel and sold the adjacent land to Walmart to construct a 4-lane access road to Walmart across the protected land. It wasn't across the creek, it was across the land, but you get the idea. Now, 2 nonprofit conservation organizations and a private citizen sued. They had standing under Tennessee's enabling statute then in existence. The development corporation, facing the possibility of having to rip up the road and restore the land and pay punitive damages, as provided in the Restatement of Servitudes, agreed to settle the case. In the settlement, the corporation agreed to convey a replacement 8 acres along the creek, as well as $500,000 to the plaintiffs to be used for similar conservation purposes, and to pay the plaintiffs not insubstantial legal fees. In approving the settlement, the trial court determined that the easement constituted a charitable gift within the meaning of Tennessee's law governing charitable assets. The purpose of the easement had become in part impossible or impractical as a result of the construction of the road, and the settlement constituted an appropriate substitute that fulfilled as nearly as possible the purpose of the original easement. Then we have Bjork v. Draper, an Illinois appellate court case, in which the court held that amendments to a conservation easement that a land trust agreed to at the request of new owners of the land were invalid because they conflicted with other parts of the easement. The purpose of this easement is to retain forever the scenic and open space condition of the lawn and landscape yard of this historic home, which is located in Lake Forest, Illinois. The land trust agreed to amend the easement to, among other things, allow landscaping that obscured the public's view of the property and was therefore inconsistent with the scenic purpose of the easement, and to remove a percentage of the originally protected land from the easement in exchange for the substitution of other land to allow for the construction of a driveway turnaround on the protected grounds. This constituted a partial extinguishment or swap, and it would have permitted a garage, carport, or some other structure to be constructed on the formerly protected grounds in contravention of the purpose of the easement. The land trust and the new owners of the land, the Drapers, they argued that the easement was merely a contract or a property arrangement that could be amended by them at will. The appellate court disagreed. It concluded that allowing the amendments would render meaningless the provisions in the easement deed prohibiting structures and requiring court approval of termination of the easement. As with the Walmart case in Tennessee, the state attorney general was not involved in the Bjork case. In Bjork, the suit was brought by a neighbor. Illinois has a somewhat unique conservation easement enabling statute because it grants standing to the owner of any real property abutting or within 500 feet of real property that is subject to a conservation easement. Next, we have the Hicks v. Dowd and Salzburg v. Dowd cases out of Wyoming. In 1993, Mr. and Mrs. Loham donated a conservation easement encumbering this 1,000-acre ranch in Johnson County, Wyoming, to the county for the purpose of preserving in perpetuity the agricultural, habitat, and scenic values of the ranch. The easement prohibits subdivision and other inconsistent uses of the ranch, and it was estimated to have reduced the value of the property by $1.2 million, and the Lohams claimed a federal charitable income tax deduction based on that amount. In 1999, the Lohams sold the ranch, subject to the perpetual easement, to third parties by the name of the Dowds. Dowds paid less than they otherwise would have for the ranch because it was subject to perpetual restrictions on its development and use. Dowds also understood that, as is quite common out west, a third-party energy company owns the rights to any minerals that might lie beneath the surface of this land, and under Wyoming law, that company has the right to reasonable access to the surface estate to extract minerals. Well, a few years later, in 2002, the energy company contacted the Dowds and began exploratory drilling for coal bed methane on the property. The Dowds then went to the Johnson County Commissioners and asked them to extinguish the easement, claiming in part that the easement had no continuing conservation value because of the drilling activity. The evidence, however, indicated that less than 1% of the 1,000-acre ranch had actually been impacted by the drilling. Apparently, the property was not a good site for coal bed methane development. Johnson County Commissioners nonetheless agreed to the Dowd's request, and they adopted a resolution extinguishing the easement and allowing the value attributable to the development and use rights to pass as a windfall to the Dowds. Those rights were worth $1.2 million in 1993, and they were likely worth considerably more in 2002. And after the county agreed to extinguish the easement, the Dowds began marketing the ranch for sale. Well, a resident of Johnson County by the name of Hicks filed suit. Hicks argued in part that the easement is a charitable asset held in trust for the benefit of the public. The county cannot extinguish the easement without receiving court approval as provided in the deed, and allowing the value inherent in the easement to pass as a windfall to the Dowds was not only a breach of the county's fiduciary duty as trustee, but also a violation of Wyoming's Constitution, which, like most states, prohibits payment of public funds to private interests. This case was argued in front of the Wyoming Supreme Court in the summer of '06. The Dowds and Johnson County argued that the easement represents a private contract between them, like a right-of-way easement, rather than a charitable asset, and that they were free to agree to extinguish this easement whenever they saw fit, despite the fact that the easement might have continuing conservation value and without the payment of any compensation to the county for the value of the easement. The Wyoming Supreme Court issued its decision in this case in May of '07. It dismissed the case on the grounds that Hicks, who was merely a resident of Johnson County, did not have standing to sue. The court did, however, invite the Wyoming Attorney General, in his role as supervisor of charitable gifts and trusts, to reassess his position with regard to the case. The Wyoming Attorney General had earlier declined to participate in this case because Hicks was already representing the interests of the public. The Wyoming AG at that time, Bruce Salzburg, filed suit in the summer of '08, arguing, like Hicks had, that the county had breached its fiduciary duty by agreeing to terminate the easement without court approval in a judicial proceeding, as required by the laws governing charities and charitable gifts and the express terms of the deed. This case eventually settled in February of 2010, with the district court judge signing a stipulated judgment that states that the deed purporting to transfer the easement from the county to the Dowds is null and void, and the original easement remains in full force and effect with some minor court-approved amendments. I also want to briefly note two recent cases in which state AGs have successfully defended conservation easements held by state agencies. The first case is Quaker Valley Farms from New Jersey. And I apologize, I don't have a picture of the actual farm. This is the only image that I could find. This case involved a conservation easement that had been purchased by a county in New Jersey with state funds and required compliance with state agricultural preservation laws. The new owners who had purchased the land subject to the easement engaged in a large-scale excavation project on this property to allow for the building of greenhouses, and in the process they stripped away many of the characteristics that made this property ideal for farming. The state entity responsible for ensuring compliance with the easement was alerted to this activity by an email from a concerned citizen, and eventually the state AG's office filed suit. The New Jersey Superior Court held that the owner had violated the easement and the state's agricultural preservation laws and was liable for destroying at least 14 acres of farmland. In a news release, the New Jersey Attorney General stated that the court's decision in this case is an important legal victory for the state. It affirms the obligations of farm owners to comply with the state's farmland preservation laws, and it recognizes the state's right to sue to enforce those obligations to preserve farms for future generations. Lastly, we have the Wooster case out of California. Wooster involved a conservation easement that was donated to the California Department of Fish and Game for wildlife preservation purposes and prohibited hunting on the property. This isn't an image of the actual property, but it is an image of property located in the same county, so you have an idea of what the property looked like. Wooster purchased the property subject to the easement, and then he filed suit to establish that he owned the property free and clear of the easement on the grounds that the department had failed to post no hunting and no trespassing signs, as was required in the easement deed, or because the hunting prohibition was void from the outset. The department was represented in this suit by the California Attorney General's Office. A California appellate court held that even if the department had failed to comply with its obligation to post this property, that failure did not extinguish the easement or give Wooster a basis for rescinding the easement. The court also held that a hunting prohibition was entirely legal and consistent with the California Conservation Easement Enabling Statute. The court explained that the natural, historical, and scenic condition of land can easily be understood as land teeming with wildlife, as it was before the advent of men, women, and firearms. Using a conservation easement to ban hunting most certainly helps to retain lands in this sort of unspoiled condition, said the court. As such, a hunting ban is unquestionably a legitimate aspect and aim of a conservation easement. Well, collectively, these cases and controversies hopefully give you a flavor of some of the issues that can arise with regard to the long-term administration of perpetual easements and how state AGs can be powerful allies to the land conservation and local communities in defending these easements on behalf of the public.